likely what you all think of as joint managing conservatorship, or whatever other language you might be using to describe joint decision making. And I know that in domestic violence cases, your law would dictate that, generally speaking, joint managing conservatorship is not going to be appropriate that is in a case of a history or pattern of violence by one parent against the other. And many practitioners end up having to struggle with the conflict between that law and its obvious belief or underlying theory that intimate partner violence or domestic violence can interfere with good parental decision making. And coercive control is the way of thinking and being in a relationship that is the most problematic for shared parental decision making. So that's what we're going to be talking about today. Two other little notes about terminology. As you can see, I'm using the words domestic violence and intimate partner violence and domestic abuse. And by that, we mean any kind of violence that occurs in a relationship between people, an intimate relationship. And we are assuming that many people use violence in their relationships and that it can mean a bunch of different things. It can be, for example, self-defensive or in reaction to being battered or coercively controlled by the other person. So we're just focusing here on that part of that nature, that context for domestic violence that is about coercive control. And finally, last term, this stuff we're talking about today should be useful both for lawyers working with people, for advocates working with people, but also primarily that we're pitching this at the practitioners that have the function of investigating for the court what's going on in the case so that the court can make a good decision on parenting, on possession, on conservatorship, and so forth. So we're talking all about both attorneys ad litem, amicus attorneys, guardians ad litem, custody evaluators, these people who have the investigative role. Okay, so the next slide, the learning objectives are these. We hope you'll be better able after this hour to define what coercive control and shared parental decision-making looks like and recognize the key characteristics of coercive control and how they might impact shared parenting arrangements. And third, we'll hope you'll be able to access the most up-to-date guidance on assessing coercive control in the context of evaluations, investigations, or other things that we are doing to give evidence to the court and to the parties. Okay. So first of all, we'd like to point out that this notion of coercive control has been around for a while. And it was actually incorporated specifically into the first national guidelines for custody evaluators when they are handling a case involving intimate partner violence. And in fact, in those guidelines, those Association of Family and Conciliation Court guidelines that were promulgated in 2016, and Gabby Davis and I served for 5 years on the committee to write them, the guidelines incorporate a broad view of intimate partner violence that includes physical, sexual, economic, psychological, and coercive, controlling, aggressive behaviors. So they acknowledge in those guidelines this national, international membership organization of custody, child custody professionals, of all kinds, they acknowledge that you can be committing intimate partner violence by coercive controlling behaviors, even where there may not be physical violence going on. So this is a critical thing. If this organization takes this up, as are many states examining the possibility of incorporating this concept into their statutes, we've got to know about it. Next slide, please. Okay, so this is primarily, largely, the definition of coercive controlling behaviors that document, those guidelines for custody evaluators, describes as this: harmful conduct, so that's not neutral, right? It's harmful, that subordinates the will of another. So this is the key from this document's perspective, and all definitions of this, is this idea that a person is making somebody else subject to their wishes and subordinating them, controlling them, their will, and so forth. And the means by which they do that is the third button here. It's through violence, intimidation, intrusiveness, isolation, and/or control. It could be any one or all of those methods. This is one definition. It's similar to many of the others, and we'll be talking about a new one that's even a bigger deal in a second. Okay, so in 2022, that is this year, the same Association of Family and Conciliation Courts promulgated new guidance for custody evaluators in all cases. So not just in the IPV cases that we talked about, the former document having addressed. And this guideline, which used to be called a model standard, it's now called guidelines, says that custody evaluators have to have foundational training and education in a number of areas, one of which is this one: family violence patterns and coercive controlling behaviors, the connection between intimate partner violence and child maltreatment, the effects of exposure to family violence, and coercively controlling behaviors on children. So this is a fundamental, very important guidance that's just come out that says you have no business doing this kind of investigative work unless you've got this kind of foundational training in coercive control. Second big point here that we should note, this document says that evaluators should also gain additional training in investigating allegations of child abuse and intimate partner violence. So everybody's got to be good at those major things. Okay, next. So there is, as I just indicated, a brand new thing soon to be released, hot off the presses, nearly off the presses, by the National Council of Juvenile and Family Court Judges. Your host and technical assistance provider, Darren Mitchell, has been extremely active in the drafting of this document and working with a extensive and diverse group of practitioners as the work group guiding this. And this very, very, very interesting definition of coercive control is being adopted for purposes of child custody, parenting, possession, and so forth, decision making. And this is going to be a section of the model code that's been in place for 30 years, but has been rewritten just this as we speak to include coercive control. So it is now, it will be shortly the case that the country is giving guidance by the National Council of Juvenile and Family Court Judges, funded by the Department of Justice Office on Violence Against Women, to look at how coercive control relates to parenting and custody decision making. The definition, after a lot, like hours and hours and weeks and months of conversation among a number of people, the definition of coercive control that we are using is this one. It has to be a pattern of conduct, so one incident would not suffice. It has to have the purpose or the effect, so that of doing bad things, which I'll get into in a sec. But what the point here is to say, in order to get the court to look at this behavior, you have to show that the person committing this coercive controlling behavior is intending the effect, or that it simply had the effect, even if it isn't possible to prove intent. Third part of this is that this behavior we're talking about has to substantially restrict, not just in a minor way, the safety or autonomy of the victim parent. Safety or autonomy. And we know what those words mean, but there's a lot of guidance in this document about that. And finally, we have to show as part of coercive control, this definition that this is a restriction on safety or autonomy is accomplished through implicit or explicit threats, intimidation, or by compelling compliance. So this is a many-factored approach to this, and we're going to get further into this as we go. Okay, so all the definitions we just ran through, the ones beginning in 2016 and preceded by a number of writings and books that have been published, including by Evan Stark over the last decade or so. All these definitions share a basic understanding that coercive control is a knowing and harmful course of conduct. It's a way of being in the relationship that makes a person subordinate and or dependent by isolating them, exploiting them for the gain of the abuser, regulating their daily lives, sometimes micromanagement, and depriving people of their means and ability to be independent, to resist the control, and to escape the abuse if they want to. All right. So you have undoubtedly seen this. It is the power and control wheel. It was put together decades ago in Duluth, Minnesota, as a result of extensive long-term conversations with survivors of intimate partner violence and their partners in separate groups. And these 8 tactics, buckets and kinds of tactics by which an abuser can take control over their partners is a really good way of thinking about how this works. That the tactics are underpinned or surrounded by or upheld by physical and sexual violence. And that's the black band that goes around the outside of that circle. So those tactics and held up by physical violence manage to create control over and power over the victim, which is the button in the middle of the diagram. Okay, so this button flying around in the middle is kind of a reminder that the power and control that an abuser of this kind takes over their victim entraps them and limits their freedom, limits their range of motion, limits their ability to act in concert with their own values and so forth. And this behavior and the result are founded in the abuser's belief that they have the right to exert this kind of control over their partners. And this sense of entitlement to control a partner and the children is what we're talking about today in its relationship to parenting. So when we think about shared parenting, which we're going to get to right this minute, we'll be able to talk about how this way of acting and being in a relationship can cause trouble for the concept of shared decision making and shared parenting. And then we'll talk about what we can do about that. So Gabby?
Great, thank you, Loretta. So as Loretta said, we're going to turn now to the concept of shared parental decision making, but I just want to reinforce that we're talking about shared parental decision making in the context of coercive control, not necessarily in the context of emotional abuse or physical abuse or defensive abuse, but we're limited here to a consideration of coercive controlling abuse. So Darren, let's go on to the next slide. So shared parental decision making or joint legal custody, or it comes by different names, and it goes by a different name in Texas. It refers to this joint authority of both parties to make important decisions about their children. And those decisions relate to things like where the children are going to go to school, what faith they observe, if they observe any faith at all, what healthcare providers they see, and all sorts of other major life issues and events. It's important to recognize that shared parental decision-making also means, and Darren, if you can go back for just a second, it also means that both of the parents have authority to make choices within these broad categories that you see listed here. So for instance, they not only decide what religion their children will observe, but how, when, where, and with whom they might take part in holidays and rituals, whether they're going to follow dietary restrictions or religious clothing and hygiene practices, whether they'll attend religious school, whether they can explore other religions or date people of different faiths. So as a result, shared parental decision-making isn't limited to these one-time decisions about where the children are going to go to school or what religion they're going to practice or who their doctor is going to be, but it includes decisions that span the child's entire growing up years. So that's an important thing for us to bear in mind. Okay, Darren, now we can go to the next slide. Shared parental decision-making is generally seen as the preferred method of child raising. And that's based on this assumption that both parents possess a shared commitment and desire and capacity to act in the best interests of their children. Now, standard shared parenting plans are also rooted in these same assumptions. And over the years, in order to arrive at those standard shared parenting plans, they've been normed to a population of parents who possess these this shared commitment. So they work really well for the population that they were designed to work for. They assume that parents are going to act in the best interest of their children, and that the best interests of their children are going to be supported by that shared parenting plan. But if these assumptions about parenting don't hold, if the parents don't share a commitment, desire, and capacity to act in their child's best interest, for instance, the shared parenting plan itself can't hold, right? So in fact, a shared parenting plan where these assumptions aren't accurate can actually harm the children. And so that's why these plans need to be examined before they're implemented. And that examination is one of the critical functions of court-appointed investigators. We have to not make a lot of assumptions. We have to really explore and analyze what's really going on. So let's delve into this just a little bit further. Darren, if you could just advance the slide. We'd like you to just take a second or two and think about the qualities or skills that are required to make shared parenting or a shared parenting plan work. And as you're thinking about this, draw on your own experience, maybe as parents, but also through your work as an evaluator or a GAL or a court-appointed investigator. So just take a minute, chat your answers into the chat box. The question again is right there. What skills are required to make shared parenting work? Healthy communication, right? Both parents putting their children's needs first. Respect of the other parent, open-mindedness, those are all really important qualities. Let's see. Any other things that you can think of? Setting boundaries, excellent, right. Not only sounding reasonable, sound reasoning, I'm sorry, I didn't read that correctly. Sound reasoning, that's right. We have to be able to trust that the other parent is making rational decisions, based on the best interests of the child. Value the other's role in the child's life, not speaking negatively about the other parent. These are all really important skills and qualities and behaviors that you're pointing out. Okay, let's go to the next slide and talk a little bit about the research that's out there. There is some research that suggests that successful shared parenting requires that the parents possess certain equipment, and they need to have socioeconomic or even cultural equipment. And by that, the research refers to that the parents need adequate resources to support separate, maybe multiple homes. They have to have some sort of geographical proximity so that exchanges are relatively easy. They must have respect for the other parent's competence as a parent, as somebody pointed out, and kind of flexibility in their approach to parenting. Those are all socioeconomic equipment that's important for successful shared parenting. There's also relationship equipment, and that includes the ability to nurture the parent-child relationship, to be supportive of the co-parenting relationship. So we need supportive relationships between parents in order for shared parenting to work. There's also maintenance equipment, and this is, kind of maintaining consistency and normality in the children's lives. And for that, we need positive and healthy living arrangements. We need positive and healthy transitions, the ability to go back and forth without a lot of stress and trauma. There's also developmental equipment that's required. And this is the parents' ability to tune into their children's developmental stages and their developmental needs, to be able to engage in age-appropriate and child-focused parenting. So parents are much more likely to make shared parenting work if they have, or at least they can access this equipment, these 4 areas of equipment. Okay, now other people have described the requirements of successful co-parenting a little differently. And if you were at David Mandel's session, you might have heard him talk about what the parents contribute to the functionality of the family. And Darren, you can advance that slide. So here, what we're trying to do, and I think that what David Mandel is trying to get at, is that we're trying to gauge whether the parents work together to create a safe, healthy, and functional living environment, or whether their behaviors are disruptive. They create harm and chaos and unpredictability and dysfunction, or some kind of combination of those things. I think that as family court professionals, and actually just as human beings, we like to think that parents bring all the qualities on the left-hand side of the screen. You know, they are nurturing and supportive and respectful and understanding and tolerant and cooperative and trustworthy, which all of these things they mirror what you all chatted into the chat box just a few minutes ago. So we want to assume that that's what's happening. But the truth is that some parents, and especially in the case of coercive controlling parents, they bring the qualities on the right-hand side of the screen. Their behaviors can be dangerous. They might be intimidating. They can be neglectful or undermining of the other parent's parental authority. They sometimes bring disrespect or contempt or intolerance. They can be demanding and unreliable as parents. And so we really have to check our assumptions here. And again, this is one of the investigator's most important functions, to explore rather than assume what's going on and what each parent brings to the functionality of the family. Right, we can move on, Darren. So we can see that in fact, shared parental decision-making can give a person who utilizes coercive control the power to intrude and disrupt and monitor and control a co-parent and or their children. Let me talk a minute about how that might happen. Let's take healthcare decision-making, for example. So having a say in the children's medical treatment can give coercive controlling abusers the power to dictate when the children see a doctor, which doctors they can and can't see, what the children can see a doctor for, and what circumstances might not warrant medical attention at all, including injuries from abuse. So that's one way. If a coercive controlling abuser has healthcare decision-making authority, they can actually undermine the protective co-parent or undermine the health and safety of the child. It's the same for educational decision-making. So, shared parenting plans give abusive parents the authority to decide, or perhaps a veto. Maybe they're not actually deciding, but they can veto how the children engage in in-class and online learning, whether they complete their assignments, how they keep current with their coursework, whether they can join study groups or engage in extracurricular activities and what those might be. They get to decide how much time the children should devote to schoolwork each day, what the homeschool structure and expectations are going to be. And that's just the beginning. There are dozens of major educational decisions to be made by parents, and those of you who are parents know this. A skilled abuser can exploit shared parental decision-making around education to further control and entrap victims. And that's because, Darren, you can move on. That's because in situations involving coercive control, you can click again, Darren, joint legal custody doesn't place the parents on equal footing as it's meant to, right? Remember at the start, the assumption is that the parents should be on equal footing. But in cases involving coercive control, joint legal custody doesn't put them on equal footing as it's meant to do, but instead it gives the abuser more opportunity and more power to intrude and disrupt and monitor and control adult and child victims. So in other words, shared parental decision-making can further this condition of entrapment that Loretta described earlier. And that's the thing that we're trying to avoid. So let's move on to a few hypotheticals to see how this might work.
Let's could we stop for a second, Gabby? So I'm sitting here thinking what meaning this might be having to people who are participating in this session. Like what you're thinking about how you might use this concept of coercive control, how you might kind of account for it in your cases, which makes me wonder, would people chat in what your role and function in these cases would be so we can get an idea whether There are already guardians ad litem or custody evaluators or other or attorneys in the room. So if you could chat in your what your profession or job is, I would love to know. Great. Okay, we have 2 judges. Hello, Judge Alvarez.
Hi, I'm happy to be here, Loretta.
Great. Nice to see you.
Good. Hello, Judge.
Hi. Nice to meet you, Gabby. I'm excited to be here. Thank you.
Great. Thanks.
All right, so we have a legal aid attorney, an investigator, an attorney. Legal aid attorney representing survivors. So far, 1 person does investigating. I mean, in the sense of any, you know, reporting to the court type of
Right.
All right, so let's assume that we have at least some people in the room who do investigations, and that the rest of the people, the lawyers and advocates and so forth, have to account for the reality of this problem in the families that they're working with, and to try to expose for the court and for investigators involved in this case what's really going on so that good decisions can come out of it. Okay, perfect. So yes, as Gabby said, let's move to the hypotheticals. So let's say one of the 2 parents refuses to disclose their home address to the other person. What are some of the possible explanations for this? What could be going on? Could you chat in, please? Everybody put in 1. Why might somebody refuse to disclose their home address? Because this is the kind of thing that obviously that's the purpose of this session. It could be because coercive control is intruding in the safety of the other parent and or the children. All right, so Veronica says, yep, safety could be at work, or somebody could be experiencing fear or violence or intrusive behavior. Okay, you're right. Any other possibilities? This is the kind of thing you can see in cases.
And Loretta, someone noted stalking, which is a very important reason, explanation.
Yep, exactly.
Second, yeah.
But of course, it's possible that something else could be afoot. So you could have, okay, Darren said, yeah, they moved and they don't want the court to know. Or the other side would say it's about keeping the children from him or her. Exactly. So hiding the children. Now, if we go down that road, why would someone be hiding the children? It could be a number of things. They're trying to penalize the other parent by making them suffer, or they're trying to protect the children from being harmed by an abuser parent, or they're afraid of kidnapping, right? It could be a number of things. So the point being, it's really important for us to avoid leaping to conclusions or making assumptions about what's going on here. We could think, couldn't someone say, the parent who's refusing to disclose their home address is being an unfriendly parent, is trying to alienate the children from me, is trying to destroy my relationship with the child, or set up the child in a family with a new other parent and keep me out of the picture from now on, right? I mean, there are a million different ways one can considerations that might be on the table with regard to this problem of hiding the children. Okay, so let's look at another hypothetical.
Well, can I just interject here that
Yeah.
I think that the point that really we want to just emphasize here is that our own interpretations of these behaviors can't stand in for what's actually happening.
Right.
That we have to know which of these possibilities is really going on. Because as you can see, they would lead us to contradictory conclusions.
Mhm.
You know, so our own interpretations, our own inferences aren't good enough. We need to
Mhm.
look for evidence to, you know, be able to distinguish, you know, what's really happening here.
Right. And what this concept of coercive control is critical, because it is something that's not as easy to see as a bruise. It's not an easy thing to describe, or even get out of a client, or even get a party to describe, because it's much more multifaceted, as you saw from the definitions, than the notion of a physical assault, or a series of physical assaults, or a threat to kill. Those kinds of things are like incidents that is much easier for people to understand as problematic. They're easier to describe as a behavior, as an incident. But coercive control is a little more squishy, you know what I mean? In the sense that you've got to ask more questions and unpack what has been experienced by the family in order to see this thing that can be extremely problematic for parenting.
Yeah.
So,
you know, Loretta and I, Darren, I'm not sure if you were part of the safety and accountability audit that we did in Northwest Ohio, but we went to Northwest Ohio and we talked to very experienced family court practitioners, and we asked them how they knew if domestic violence was going on. And so many of them said, you know, I can tell, I can feel it in my gut. I know it when I see it. And in actuality, the things that they were looking at to make that determination really had very little to do with what was happening in these lives of people that they were working with. And so I think that we all like to think, because we've been doing this for a long time, that we get it. And I think that practitioners often make assumptions, and this is true whether you're a seasoned domestic violence advocate or somebody who knows very little about domestic violence, is that naturally we rely on our own assumptions. And I think that what our suggestion to you is that we put our assumptions aside and really do what Loretta just suggested, really explore what's going on.
all right, so let's look at another hypothetical, if we could, Darren. Thank you. So let's say you are working on a case and one of the parents feels uncomfortable leaving the child with the other parent. They don't want to agree to it. They might be failing to show up with the child when they're supposed to turn the child over, that kind of thing. So what are, if you could chat in, please, as you did last time, what are some of the possible explanations for this phenomenon? Somebody doesn't want to leave the child with the other parent. All right, so one, I was listening to a young man, a college student, in a webinar yesterday talking about his case. All right, so usually I go with the most obvious explanation. They don't trust the other parent's ability to treat the child well. Yeah, it could be they're just afraid that the child would get hurt, or maybe that the other person just doesn't know how to parent, right? Maybe they're not violent, but they're clueless. There's drug or alcohol abuse as a possibility, right? And past abuse. This case that I just heard about, this young man was the subject to incredible litigation abuse, he and his mother, his entire lifetime, beginning when he was about 5 months old. And by the time he was a teenager, he and his mother didn't even want to be at home. For example, on his 19th birthday, he got a message from his father saying, "You're a loser, you'll never get into college, happy birthday." Because the father was angry at the child for, after years and years of a physical and sexual abuse and litigation abuse of his mother, he stood up to his dad, and his dad wouldn't stand for it. And this is the kind of thing that, in his case, the physical and sexual violence occurred when he was very, very young, and his mother left his father, and all the rest of his life up until that point had been coercive control, and just had the potential for ruining this child's life. But Cynthia says they've seen that the other parent is neglectful or loses patience with the child, worried about the shift of the abuse from the victim parent to the child. Exactly. That's a not uncommon thing. When people lose access to the other parent in terms of victimizing them, they take it out on the child. All right, so could we go to the next slide? So here's some examples of how it is that one parent could feel uncomfortable leaving the child with the other parent. They reasonably fear for their safety. They unreasonably fear for the child's safety. Like it makes no sense that they would worry about it in this case. Or they worry about the competence of that person to parent, or they're concerned about where the child is actually going to, like the home that they're staying with the other parent, or they're trying to interfere with the relationship between the child and the other parent. And as you can see, these are just 5 explanations, and they vastly differ the first to the last.
Mhm.
If the situation is that the kid is in fact endangered and the parent is uncomfortable, leaving the kid with the other parent because they reasonably fear for that kid's safety, that requires a very different response than interference with the other parent's relationship with the child.
Right.
Which can actually a coercive controlling abuse tactic, by the way.
And I think that last thing that you said is the most important thing, is that we have to figure out what these, problems are rooted in. So if they could be rooted in coercive control, and then we'd have one response. If they're rooted in mental health problems or substance abuse or just poor preparation for parenting, we have to figure that out, because unless we know what's really going on and what the root of these problems are, then we can't come up with good solutions.
Right on. So let's move to the next slide. One thing that we do know, and it's that all of the guidance for evaluative personnel in the family court system, guardians ad litem, custody evaluators, attorneys for the child, and so forth. These people are being charged with, and it is assumed that they are competent to and do assess the nature of the co-parenting relationship between the parties. And that means they have to assess whether coercive control is one of the features of the abuse. Every one of us in the family court system now, because of what we know about abuse, the research that's been done, all the developments in the field, we have to fully understand and be able to suss out what, whether coercive control is going on, and if so, what it does it look like, and what is the result of it. All right, could we go to the next slide? And then Gabby can talk about one of the ways we can do that difficult work.
Great, thanks, Loretta. So in order to arrive at parenting arrangements that don't reinforce coercive control, it's really important for us to identify whether abuse is an issue in the case, and if so, how it's likely to affect parenting plans. So only then can parenting arrangements be fashioned that prevent further abuse post-separation. So we've referred several times to SAFER. This is a framework that has been developed over lots of years with lots of expertise. It didn't just pop out of our heads, but it's rooted in good research, and we had a lot of input from the AFCC and the National Council of Family and Juvenile Court Judges and communities all across the country. But we developed this in order to help professionals systematically screen for domestic violence or IPV in every single case. And it's not going to be in every single case. And so sometimes you screen for domestic violence, you don't find it, and then you're through unless and until you get some other indication of it down the road. But sometimes screening for IPV does reveal some kind of physical, sexual, emotional, financial, or coercive controlling abuse, some indication of abuse. Maybe there's a protection order. That's enough to do a screen for domestic violence, for a positive screen. But if domestic violence or IPV is identified, the next thing that is really important to do is for practitioners to assess the full nature and context of the abuse. That is really to figure out what exactly is going on, who's doing what to whom. And then we want to focus on its effects. And for our purposes today, what's the effect of the abuse on the parenting arrangements? So we want to figure that out. How does it affect the best interests of the child? How does it affect the co-parenting relationships? How does it affect each parent's capacity to parent? And then once we know that, then we want to fashion responses that really try to address and correct whatever problems we identify. So we know that there was a presentation yesterday on SAFER. This is something that the Battered Women's Justice Project in Minneapolis is continually working on and updating and sharing and training on. If you missed that training, you can contact the folks at BWJP and make inquiries. And Darren, on the next page, there's some contact information. So you can get more information at www.bwjp.org. But this is a framework that we're really recommending that folks follow. We have a lot of supporting materials and resources that help people implement each of these different tasks. We have screening and interview guides. They're available at the BWJP website free of charge. We have a bunch of resources that help folks assess the nature and context of abuse so that they can differentiate coercive control from other forms of abuse. We have a lot of material that helps you really zero in on the effects of IPV, the potential effects, and how to talk to clients if you're an attorney or advocate, but also parents if you are an investigator of some sort, or even a judge who is considering the case. And then we have also resources that help people think of maybe some interventions or responses that aren't just, cookie cutter, out of the drawer responses. So it's more than just deciding who gets to make the decisions and how much time each parent spends with children. Those are important things to include in a parenting plan, of course, but they don't necessarily address and correct the problems that IPV can create, especially coercive control post-separation and even post divorce or dissolution or whatever the the legal framework is.
And Gabby, could I add to that the tools that we created that are available on that website are the kind of tools that even very busy practitioners use. And they find that it helps them focus on the kinds of things that are going to be critical for them to understand about the case. So, the high volume family lawyer working for legal services or in private practice who wants to be sure they've actually got the full picture of what's going on in the case and whether coercive control is going to ball up this whole family so that a year from now the child is in desperate straits because we got it wrong the first time. The way to do this is to use this kind of material to ensure that you've covered all your bases. You don't have to just remember and go back and contact the person again and ask another question. You can get the full picture in whatever amount of time you're actually allowed to put in on a case for whatever reason. This, as we've indicated, coercive control can be extremely problematic, and mostly because, and standard orders not useful, because the people who are using coercive control are doing it because they believe they're entitled to run the life of the other person, to punish them, to control them, to entrap them, and in many cases also feeling that same way about the children. And that solid fundamental belief system does not change overnight. And it doesn't change by virtue of a separation. It doesn't change because of a court order.
Yeah. And
So,
you'll notice, I'm sorry, Loretta,
No,
I
no,
didn't mean
good.
to interrupt, but
Mhm.
you'll notice that we don't advocate a particular outcome
Right.
for domestic violence cases. There's no such thing as a standard domestic violence parenting plan, because it manifests itself in so many different ways. And so what SAFER helps you do is to conduct the analysis to arrive at the conclusion that makes sense for this particular family. It doesn't demand a certain outcome because it's impossible to do.
So we hope you'll find this information useful. We hope that the concept of coercive control will start showing up more clearly for you in your cases where it exists. So you'll be able to account for it in cases that will, in a way that will ensure that children and parents thrive after their separation. So thank you for inviting us. Lovely to see you.
Thank you so much, Gabby and Loretta. I really appreciated that. Especially the points around not making assumptions about what's happening in the family, and that we really all have a duty, no matter what our role is in family court, to understand that the abuse that's happening can strongly conflict with what's necessary for joint
Right.
parental decision making, which we all in so many cases feel forced to go toward. So thank you. You all have a 15-minute break before the next session, and which will be a plenary session. And thank you all for spending time with us this morning, and really join me in thanking our amazing presenters. We really benefited from you taking the time to share your latest thinking on these issues. Take care, everyone.
Thank you.
Thank you. Bye.
Enjoy the rest of your symposium.